to access the recording after the presentation in your video resource archive in the Member Information Center. So I just want to say welcome and good morning again, and thank you for joining us on this morning's webinar. I am Christina Groff, President and CEO of the Cheektowaga Chamber of Commerce, and we're so glad to be joined by our champion partners and members of the team at Hurwitz Fine PC presenting today. We have Joe Brown, a member with the Labor and Employment team, Stephanie McCants, an associate with the litigation department, and Ryan Maxwell, an associate specializing in insurance coverage. Obviously, today's topic is a critical one and certainly relevant to what we're going to need to be discussing. As we were kind of talking a little bit beforehand, we recognize that this will be ever evolving. So we're fortunate to have the connection with Hurwitz Fine and the membership through the Chamber of Commerce that we do, so that we can continue to provide information as we go along. I just want to a few housekeeping items. Note at the bottom of your screen, you'll see a chat feature as well as a Q&A function. We encourage you to engage in the chat box and pop any questions that you may have as the speakers are presenting today right there, and we'll be able to answer them at the end of the presentation and engage in some back and forth. So with that, I think I will turn it right over to you, Joe. Thank you for being here.
Thank you, Christina, for having us. Thank you for all of you who are tuning in this morning. Having provided numerous presentations on COVID-19 related topics over the past year, it's refreshing to talk about something that has nothing to do with the pandemic, New York's recreational cannabis law. So my firm has formed a practice group to advise clients on issues related to the cannabis law. And what we're going to do is provide you an overview of what your business needs to know about New York's recreational cannabis law. So I'll start with my usual disclaimer that we are not providing legal advice, we're just providing information. And as Christina mentioned, the important thing to note is this information is going to continue to evolve as we wait further guidance and regulations from New York's Office of Cannabis Management. Just a quick overview of what we're going to do today. Stephanie is going to provide an overview of the Marijuana Regulation and Taxation Act. I'm going to walk us through some of the employment law considerations, and then Ryan Maxwell, who's an insurance coverage attorney, is going to talk about the business insurance impact. And then finally, we hope to leave some time at the end for questions and answers, so you can put those in the chat box, and Christina will help moderate that discussion. And with that, I will turn this over to Stephanie.
Hi, everybody. Good morning. My name is Stephanie McCants. I am a litigation attorney for Hurwitz Fine, and I'm going to give you all a brief overview of the key features of the new marijuana law and how it all applies to us here in New York. So a brief overview to my overview. I'm going to be running through what is now legalized as a result of the MRTA, this being adult recreational use, as well as the production and distribution of marijuana and marijuana products in New York. I'll also be touching on the criminal justice reform aspects, which are a guiding feature of the law, and the new regulatory framework we expect to see to facilitate all of the upcoming changes. And finally, I'll touch on personal protections. So those are your rights if you choose to consume marijuana, and the necessary workplace safety features that might go alongside that. Now, unfortunately, the new law as it stands, it does currently raise many more questions than it answers. So I will be splitting my section up into what changed immediately with the new law being signed in March of this year, what we expect to see around 6 months from now, and then finally what we expect to see about 18 months from now. Next slide, please, Joe. So the marijuana law implemented several changes immediately when it was signed by Governor Cuomo on March 31st of this year. First and foremost, of course, the marijuana law legalizes adult recreational use and possession of marijuana and marijuana products for anyone over the age of 21. You may now smoke marijuana at home or anywhere outside where the use of tobacco products is allowed. And you can hold up to 3 ounces of marijuana products That's marijuana flower, and up to 24 grams of marijuana concentrate. So that is oils and tinctures. Any more than that, and you will be subject to a criminal violation, punishable by a fine of up to $125. Use of marijuana or the smell of marijuana is now no longer considered probable cause for a law enforcement officer to conduct a stop, search, or arrest. And while legalized sales have not yet taken effect, so you cannot buy or sell marijuana at the moment, you can transfer it from one person to another so long as no money is exchanged. And along with this automatic legalization comes the automatic expungement and resentencing of past nonviolent convictions for anything that is now legal under the new law. So if you or someone you know has a prior conviction for possession of marijuana that is no longer illegal, you are entitled to have your criminal record with respect to those violations destroyed. And that includes destruction of any mugshots or fingerprints that were taken in connection to those offenses. In order for that to happen, however, you do need to make a formal application to the court in which you were sentenced, but it's really easy. You just fill out a form and you mail it in, or you hand it in yourself. It is worth noting here, however, that marijuana is, of course, still a federally controlled substance. Its possession is still considered a federal offense. And so any prior criminal convictions that you have for marijuana possession, though they might be expunged in New York, they will still be available on federal background checks. So if you apply to become a federal officer or to join the military, that is still going to show up. Now, if you want to keep up to date with the upcoming regulations as they're rolled out, you can head over to the Office of Cannabis Management website. Now, the OCM is set up to create and implement all of the regulations and procedures that have to be implemented to facilitate the production, sale, and use of marijuana. And they have three main goals, the OCM. Number one, their overarching goal is to promote social justice issues and to address past harms caused by the criminalization of marijuana. Number two, their goal is to promote public health and safety. So things like production standards of marijuana products, including strict labeling and testing requirements to ensure that consumer protection and the type of, to ensure consumer protections and the type of advertising that will be permitted, similar to alcohol, you can't advertise it to children. And finally, the OCM, their third goal is regarding economic development. They want to encourage small businesses, farmers, veterans, minorities, and women to participate in the industry. New York is poised to become one of the largest state legal cannabis markets in the country. So there really is big business to be had as a result of the law, and the OCM is very clear about where and how they want those businesses to be created. Next slide, please, Joe. So what can we expect to see happen in the next 6 to 12 months? Well, we're going to see a lot of new regulations starting to be rolled out. First, we're going to see an expansion of the existing medical marijuana and cannabinoid hemp programs. Cannabinoid hemp, for those that don't know, it is the same plant species as marijuana. It just contains less than 0.3% of THC. So if you've noticed a big boom recently in CBD products, those come from cannabinoid hemp. And for both medical marijuana and CBD, the new law allows the sale of marijuana and hemp flower, as well as smokable forms of each, whereas previously only tinctures and concentrated products have been allowed. Now, while that is exciting, the big news for the medical marijuana industry is that the list of conditions that doctors will now be able to prescribe marijuana treatments for has been exponentially expanded. The list now includes conditions like Alzheimer's, arthritis, autism, anxiety, but in fact, it includes any other condition that a treating doctor certifies as being treatable by marijuana. So really anything could result in a medical marijuana prescription from your treating physician now, or at least in a few months when the new regulations are rolled out. Medical marijuana patients will also be able to grow up to 3 of their own plants at home once those regulations are rolled out, which again, we expect to see in the next 6 months, and certainly sooner than recreational cultivation, which I will be getting to in a minute. And finally, by the end of this year, so December 31st, 2021, municipalities across New York State must decide whether they intend to prohibit retail cannabis businesses from selling their products locally. So towns, villages, etc., they have what's being called a municipal opt-out. They can't make it illegal to use marijuana, but they can decide that they don't want dispensaries or smoke lounges in their jurisdictions. This is the only time that they will be able to opt out. But if they do so and then change their mind, they can opt back in later. And we already know of 4 coastal towns in Long Island that have announced that they plan to opt out. Next slide, please, Joe. So around 18 months from now, we're looking at late 2022. That's when we expect to see recreational sales rolled out in New York. So for anyone interested in producing or distributing marijuana products, the OCM will be creating an application process. Now remember, as I said, their overarching goal is to address the past wrongs that prohibition created. So their goal is to award 50% of production and distribution licenses to minority and women-owned businesses, distressed farmers, and service-disabled veterans. Additionally, you'll not be allowed to hold multiple licenses, and that's to avoid any large corporations developing a monopoly over the market. From a licensing standpoint, the recreational market will be split into 2 tiers. We're going to have cultivators in charge of the production, processing, and distribution of marijuana, and then we're going to have retailers making the direct sales of the products to consumers. The market is definitely being geared towards the micro business model that we've seen with breweries and distilleries. So you can expect to be able to enjoy some sort of cannabis tour late next year where you can go on site, see how they're creating the products, and also try and buy some of the products to take away with you if you so choose. And we'll also see the creation of consumption lounges or smoke lounges where you can buy and consume marijuana products on site. And those businesses will be prohibited from also serving alcohol. So not like a bar that suddenly is also serving joints on the side. It's going to be one or the other. The law also contains provisions for the home delivery of marijuana products. So we'll probably see those that rolled out late next year. And if you have a bit of a green thumb and you fancy giving it a go yourself, New York residents over the age of 21 will be permitted to grow up to 3 mature plants and 3 immature plants at home for themselves, with a limit of 6 and 6 of each per household. And other key features of the MRTA, finally, we're going to see taxes. Taxes, of course, on marijuana products. Those are going to be tiered depending on the type of product. So we're going to see different tax levels depending on whether it is a flower, an oil, or an edible. All taxes will be deposited in the New York State Cannabis Revenue Fund. That fund will be split 3 ways. So we'll see 40% going to education in New York State, 40% to community grants reinvestment funds, and finally 20% to drug treatment and public education funds. New York's Department of Health will also be conducting a research study to evaluate technologies for the detection of marijuana impaired driving, after which there may be various rules and regulations implemented for approval and also to certify a test for law enforcement to detect whether drivers are actually impaired by marijuana consumption. Now, just for the record, it is still illegal to drive while impaired by the influence of marijuana. There is no device currently on the market for employers or law enforcement officers to be able to detect that. So I am aware of several products that are being tested, that are being examined to see if those would be effective, but at the moment there isn't anything. Any discrimination on the grounds of cannabis use will be prohibited. You have a right to consume marijuana if you so choose in New York State. So, for example, landlords cannot refuse to lease or otherwise penalize a tenant for consuming marijuana except in certain circumstances, such as where the property has a smoke-free policy in place and you decided to burn a big fat one anyway. Not okay. The landlord, or if the landlord stands to lose benefits under federal law or regulations. And there are similar protections and exceptions for university students. But it's important to note in all cases that there must be an exception for medical marijuana. That is a prescription, that is a medical treatment, and you absolutely by right have the right to consume that as your treating doctor has advised. And finally, workplace safety protections will be implemented likely in the coming weeks and months. Employers might create or enforce policies related to marijuana use, which prohibit impairment on the job. And I believe Joe is going to go into that in much more detail next. And I've hit 15 minutes on the dot. So thank you, everyone. And if you have any questions, pop them in the chat and I will get to them at the end.
All right, thank you, Stephanie. Again, I'm Joe Brown. I'm a partner in the Labor and Employment Group at Hurwitz Fine. And I'm going to talk a little bit about some of the employment law considerations. So while Stephanie mentioned some of the timelines that are applicable, for example, the sale of cannabis will not likely become legal until sometime in 2022. Individuals age 21 and over are immediately permitted to use cannabis without violating New York state law. And the important employment law consideration is that this law basically creates a new class of protected worker, the recreational marijuana user. So in the next few slides, I'm going to kind of go over what that means for employers and some of the next steps as we move ahead. So the first question I pose in the next slide is, can an employee possess, use, sell, distribute marijuana in the workplace? And the answer is generally no, but it may depend on your workplace policy. So there's nothing in the act itself that prohibits employees to possess, use, sell, or distribute marijuana. In fact, the act prohibits the smoking of marijuana wherever the smoking of tobacco is prohibited. So employers may still prohibit that kind of conduct in the workplace, but to that end, a good written policy is essential for employees to know what the rules are and what the expectations are. Another questions, and probably the main one for my portion of the presentation, is what protections do employees have for off-duty marijuana use? And this gets us into a discussion of Section 201D of New York's labor law. So for a number of years, there's been this provision in New York labor law known as the Lawful Activities Act that prohibits employers from discriminating against employees because of their outside activities, whether it's legal, political, or recreational activities when they're conducted outside of the workplace and outside of work hours. So what this law does is it amended the act to provide that the recreational use or consumption of marijuana outside of work hours and off of an employer's premises constitutes a lawful recreational activity. So based on the definition of work hours under the law, it's clear that an employee's use of recreational marijuana is protected only to the extent that it occurs prior to the beginning or after the completion of an employee's work hours. So in other words, an employee can't go on their break, use recreational marijuana, and then, doesn't matter if they're being paid or not for their break time, because that would not be protected. Another big question is, of course, how should I handle discipline or discharge if I suspect my employee is impaired on the job? And this gets us into a discussion of some of the exceptions that are set forth in this amended labor law 201D. It says employee must show that the employer must show the employee manifested specific articulable symptoms while working that decrease or lessen the employee's performance of the duties or tasks of such an employee. Such specific articulable symptoms that interfere with an employer's obligation to provide a safe and healthy workplace. And we don't have any specific guidance as to what specific articulable symptoms mean, and we'll address that in a later slide. But one of the biggest challenges for monitoring marijuana use is that there's the lack of a testing process to accurately determine the time of use. So under current testing, a lot of times you can tell, if an employee has used marijuana sometime over a period of several weeks, but a test itself won't tell you the employee is intoxicated as of this time. And my understanding is that that technology is still under development, but this kind of, in contrast, like for example, to alcohol use, where you can give a blood alcohol contest or a breathalyzer test to kind of figure out at a moment in time if an employee is considered legally impaired. So as I'll talk about in later slides, you're going to want to tread carefully if you have a situation where an employee you suspect is impaired in the workplace, and I'll get into those kind of considerations in a bit. So, is an employee up to work smelling like marijuana enough to discipline the employee? And if not, what symptoms would qualify? Again, an employee's or clothing or personal items could feasibly smell like marijuana due to use long enough before a shift where they would not be impaired for their shift. However, if the employee smells of marijuana and there are some additional symptoms that lead the employer to believe the employee is under the influence of marijuana while at work, and that smell in combinations with those symptoms may be enough. It's kind of a vague description at this point, but unfortunately that's all we have until further case law or state guidance evolves as to what constitutes specific articulable symptoms. So hopefully that's something we will see in the months to come as we get further regulations on this. The other exception in section 201D, where an employer can show that they do not have to, or they can take an adverse employment action against an employee, is where the employer's actions are required by a state or federal statute, regulation, or mandate, or they'd be required to commit any act in violation of a federal law, which would result in the loss of a federal contract or federal funding. So, another complicating factor in all of this is that cannabis is still illegal under federal drug laws. Under federal law, marijuana is a Scheduled I controlled substance. And there's some momentum in Congress to change this, but as of now, we have this conflict. So if you're a federal contractor that has to comply with the Federal Workplace Drug-Free Workplace Act or other regulations, you have some decisions to make. The good news is that we know that New York law provides an exception. The bad news is that we do not know how regulatory authorities and courts are going to construe this exception. So this is definitely an area where you're going to want to consult legal counsel for further guidance. The other big question that comes up is the impact on drug testing policy. So nothing in the Act prohibits drug testing, but its value as a screening tool now is somewhat limited now that employers cannot refuse to hire, discharge, or otherwise discriminate against an individual if they test positive. So if you believe an employee is under the influence of marijuana at work, testing might seem like a good option, but as I pointed out before, there's a difficulty with drug testing is that the current lack of a test to determine when an employee used marijuana with specificity. So, current drug tests for marijuana could reflect use that was off duty and that was therefore lawful. The same goes for pre-employment drug testing for marijuana, and that essentially loses all value under the new law as the employer is not using the test to determine whether the employee was impaired at work. So as a result, any positive test from a pre-employment drug test could feasibly relate to off-duty conduct and would therefore be a lawful use. And employers who intend to expect or to continue their drug testing employees should remember that they cannot, apart for those instances with the three exceptions that I just mentioned, discharge or otherwise discriminate against an employee for their lawful use of cannabis. And then in the union context, if a CBA requires drug testing, the employer again must be vigilant about how they are going to use those test results. As an aside, a CBA that prohibits off-duty use of marijuana is now unlikely lawful, similar to an employer policy that prohibits off-duty cannabis use. One question that comes up, what if my company's client has a blanket prohibition on marijuana use? So if you have a client that has that type of policy, you're going to want to discuss that new law with your client, make the client aware that you as the employer cannot take an adverse action against the employee for off-duty use of marijuana. And then again, advise your client if they have any reason to believe one of your employees is using marijuana while on duty to inform you. But as the employer, you are liable for a potential lawsuit an employee may bring for discrimination based on the lawful use of marijuana. So while your client may have a valid concern, it's the employer is going to be left on the hook for such a claim. And then on the next slide, I just wanted to kind of highlight and provide a reminder about medical marijuana. Stephanie kind of alluded to this topic in some recent expansion of the use of medical marijuana. So keep in mind that New York human rights law has prohibited discrimination against employees and job applicants based on the lawful use of marijuana since 2016 with the passage of the Compassionate Care Act. So the provisions of the CCA amended New York State human rights law to protect employees and job applicants who lawfully use medical marijuana. And the CCA provisions were similar to the new law and included an exception for employees who, report to work under the influence of medical marijuana. And essentially the new law is a broadening of this existing standard to include employees and job applicants who use recreational and medical marijuana off duty. Under New York State human rights law, again, employers have an obligation to accommodate individuals with disabilities. So employers will need to be mindful of those obligations, engage in an interactive dialogue with employees who are certified patients under the Act, and where possible, reasonably accommodate employees with respect to underlying medical conditions. Under the Americans with Disabilities Act, permitting the use of a drug made illegal under federal law is not a reasonable accommodation, but New York law appears to reach further. So bear in mind that New York law does not require an employer to accommodate a medical marijuana user by allowing that user to carry marijuana onto work property or to use it on work premises. And then on the next slide, I just highlight some of the next steps for employers. Again, if you have a drug testing policy or any type of drug-free workplace policy, that you're going to have to carefully look at it to make sure that it's compliant with the new law, modify any hiring, employment, drug use, and testing policies and procedures. At some point, it's going to be very important to train your supervisors and managers to recognize the signs of marijuana impairment, and hopefully we'll get more guidance on this issue about specific articulable symptoms. But it's going to be imperative for employers to train their supervisors so that when they are in a situation where you have to take an adverse employment action, you have the documentation available to back up that claim and not just say, hey, Tommy, showed up smelling like weed today and not really have the record to really support an argument that there are specific articulable symptoms. So definitely need to train supervisors and managers in that regard. And then again, stay tuned for further regulations. We are certainly trying to stay apprised of the latest updates, regularly, updating our newsletter and our firm website. That kind of this is just an area that's constantly evolving. So you'll definitely want to make sure you have a source of information where you're staying up to speed on these new developments. The other issue that comes up is, what about the insurance coverage options? So Ryan is one of our insurance coverage attorneys. He's been staying attuned to what the industry is doing, and he's going to walk you through some of those issues. Thanks, Ryan.
Thanks, Joe. Yeah, I guess this is the part where I say another disclaimer. Unlike Stephanie and Joe going through the legislation we have, all we have really in the insurance industry in New York State from the Department of Financial Services is essentially a press release that says they're working on it. So DFS at this point is looking into the issues with respect to the legalization of this recreational marijuana and how that plays with insurance in both the cannabis industry and business insurance policies generally as well. So at this point, we don't have a lot of solid information, but we do have some predictions based upon what we've seen elsewhere across the country. And we have to remember at the very beginning that insurance itself is it's a state regulated industry. So the McCarran-Ferguson Act basically says that this particular product, all business insurance is regulated at the state level unless a federal statute is put in place in a particular area for a particular type of insurance to regulated at the federal level. That is not the case here, as there is no federal regulation of insurance for cannabis. So what we're left with is a state that has to figure out how are we going to handle a very important piece of the puzzle for all types of businesses and in all types of industries. So what we do know is that there's insurer reluctance to step into the fold at the beginning here because there's this federal legislative void. Now, Joe had mentioned that there's been some headway made recently with respect to attempts to either legalize marijuana or at the very least find solutions for businesses that are attempting to enter the cannabis industry and do it the right way. And so that federal legislative void is either going to be some sort of legalization or at the very least some sort of leniency with respect to banking or insurance to be available for certain types of businesses. What we're seeing is that in states that have already gone forward with what DFS is doing now, analyzing their insurance products and their insurance regulations, is we're seeing small insurers, excess and surplus lines insurers, and not admitted carriers stepping into some of those voids, taking the first step in trying to put products into the market so that those in the cannabis industry can actually find a coverage that is going to help them with the specific needs that they have in their business. And what we found is that the Cannabis policy is really the one that we've seen most often. It's a business owner's policy that is specifically tailored to cannabis products and cannabis businesses, whether that's manufacturing, whether that's distribution, selling, advertising. They've taken these forms, and what they've done is, they've kind of modified them of sorts. And I think that kind of leads into our next slide, which is this Cannabis policy overview. Now, this is a very tailored and specific product, that's being issued again by these small carriers. And what they're doing is essentially saying, listen, we understand that cannabis is legal in New York State or California or Colorado, wherever you're located. And what we want to do is create a policy for you that provides coverage so long as you follow all of the instructions that Stephanie and Joe overviewed when you're dealing with this type of product. So coverage will be conditioned upon compliance with state law and regulations. They want to make sure that you're not running afoul of, at the very least, the state regs that are put in place, so that even if there isn't a federal allowance for your type of business, so long as the state says it's okay, we're willing to step into that void and provide some sort of insurance coverage. Again, this, because it's not legal at the federal level, we're looking at intrastate commerce only. So these businesses are confronted with issues in supply chain and manufacturing using products locally, and it has to be specific to intrastate. The second that anything goes out of state, these Cannabis policies that we've seen, none of which are standard. Again, these are, we're kind of creating these coverages as we go. Those types of coverages are going to be focused specifically on your business in New York State using New York State products and shipping only within the confines of the borders of New York State. Then we get into a few more specific types of coverages that are included, whether that be crop insurance or coverage for theft. Again, these businesses have trouble with banking and funding, and so they need to make sure that they have the ability to have coverage, but insurers are more willing to provide a limited coverage. So if you're going to have a lot of cash on hand, we're willing to provide you a certain amount of coverage for the cash and these products, these very lucrative products that may entice theft and criminal activity. So we need to make sure that the insurers are limiting their risks. So you'll see some limited coverages there. And again, these are recycled forms. So we have a potential for gaps in coverage when we're looking at industry-specific products for cannabis. As we evolve and as we have more information regarding how these coverages apply, we may see more standardized products. But again, without a federal opening of the floodgates, we're less likely to see that right away. In the cannabis industry, there's other additional coverage considerations. So we're seeing there's directors and officers liability stemming from uncertainty in the business. So we have there's the insurers are reluctant to issue a lot of this directors and officers coverage because they're not quite certain how directors and officers are going to handle the situation as we have these upstart businesses stepping into the fold and moving forward. So that's a difficult coverage to get right now. Cybersecurity, again, you can't just sell a lot of these products to people without collecting information from them, and that leads to the risk that someone is going to enter your system and collect or I guess steal that client information. So cybersecurity is another issue that the cannabis industry needs to find solutions for an insurance product. Product liability, there's a lot of experimentation in the marijuana industry. A lot of different types of products that are entering and how they're advertising those products. We see issues with labeling and advertising, and those are really some of the claims that the Cannabis producers are trying to find solutions for in a way that is something that an actual business can potentially purchase. Workers' compensation is always going to be an issue, but again, workers' compensation is mandated by New York law, and so those products are available. Again, you'll see smaller insurers that are stepping in to pick up that potential burden, but workers' compensation is probably the easiest coverage for these types of companies to come by. Cash and contents, we talked about it before. Without banking, you have a lot of cash on hand in these businesses. So those are the types of those types of coverages provide a some limited coverage so that you don't lose everything you have because you had to have a lot of cash on hand. Crop insurance is an issue as well. You're not eligible for the federal crop insurance program. The cannabis product is not legal at the federal level, so you don't have that product to go to and enter that particular industry. So crop insurance, again, is a sublimited coverage that some of these cannabis producers are producing. And fleet and auto and cargo covers. Again, you have human drivers. There's always going to be a fear that somebody is going to, I guess, get high on their own supply, right? So insurers not having the ability to have a lot of data and information make assumptions. One of the assumptions being that either the drivers are going to drive in some sort of intoxicated state, and again, there's that high valued cargo. It increases the insurer risk to potentially have some sort of hijack, moving money around, cash again on hand, those types of things. Which leads us to really marijuana insurance for other businesses, and what's the impact for the other types of businesses that are not in the cannabis industry. Again, it really boils down to, at the federal level, we don't have a federal solution. And there's a lot of the larger carriers are going to have issues with respect to ensuring any type of risk that's going to run afoul of some sort of federal law. And being a financial institution dealing with money, the same reason that banks don't want to step into the fold oftentimes for these issues. They don't want to run afoul of some sort of federal law. So again, there's no real standardized forms, but what we're seeing is that without the federal legislation, there is a tendency for insurers to issue some sort of absolute blanket exclusionary language. We do not provide coverage for the sale, manufacturing, distribution, or consumption even of these products. And a lot of insurance companies are looking to potentially get out that way. Now, we haven't seen really any forms yet in New York State. It's very early on, but you need to keep your eyes open when insurers start to introduce these types of exclusions and endorsements in your policies, and make sure that you have somebody take a look through what that exclusion is what impact that particular exclusion is going to have on your business. Now, with some sort of federal legislation, we would anticipate that what you'll see more so is something along the lines of your liquor liability exclusion that is in a standard CGL coverage. The liquor liability exclusion excludes coverage for the sale, distribution, manufacturing of alcohol because you're not in the business of doing that. So long as you're not in the business of selling or distributing alcohol, that particular exclusion doesn't apply to you. So with federal legislation to allow these carriers to step into that fold, these exclusions would be a little bit more limited in their scope. Now, both of these examples actually are pulled from exclusions that I've seen on non-standard forms again. So these exclusions do exist, and that really just boils down to, again, keeping an eye out for when an exclusion is introduced into your policy. You need to make sure that you read the scope of that exclusion. You ask your insurance professionals, your broker, your agent, what the reach of that exclusion is, to ensure that you understand how that particular exclusion will impact your particular type of business. And with that, I think sliding back to Joe for question and answer, I believe.
Yeah, thanks, Ryan. And I know, Christina, looks like we have a few questions in the chat box. So if you want to go through those.
Of course, yeah. So we'll start with one that is a little bit more general. So looking at regulations as they are related to the MRTA. So someone asked, are there different regulations, or what are the regulations in a vehicle? Is it 3 ounces, or is it 3 ounces per person 21 and older in the vehicle? Are there anything, are different specifications there?
Sure, so I can take that one. So the regulations say it's 3 ounces of the marijuana flower product per person, and you can have that outside of the home. So that would include in your vehicle. I would say that if you have multiple people sharing a vehicle, or you are, I don't know, taking a big road trip or something with several people bringing their own marijuana, I would say it's probably a good idea to make sure that you separate that out. Make sure that everyone's marijuana is kept in their own bag. Sort of, you have to make sure it's kept away from children, and just don't commingle it, so that you aren't sitting with more than the 3 ounces kind of commingled. Because if you were to get stopped and searched for a different reason, that could potentially cause some problems. So that would be my recommendation in that kind of instance. So yeah, I would say that you can keep 3 ounces per person in the vehicle, just keep them separated.
Great, thank you. And someone commented here as well, it sounds like the restrictions seem to be a bit more lenient than alcohol. Is that kind of a correct assumption?
Yeah, I think that would be a correct assumption. I was actually a little surprised when I saw that. I was expecting the regulations to be quite similar to liquor laws, so you can be observed to be consuming it, walking down the street or out at the park, for example. But they went the opposite way. They've sort of followed the Clean Air Act and gone with, tobacco smoke instead. So anywhere that you can smoke tobacco products, you can smoke marijuana. So it is more lenient than the alcohol requirements, yes.
Thank you. So kind of shifting gears a bit to more on the employment side. So we had a question in the chat box. So I know it's a bit vague with the specific articulatable symptoms, but say that is clearly visible and meets that criteria. What should someone do if someone shows up for work and they're high?
I think, the immediate thing to do there is you want to make sure that you're not having an employee who is going to be endangering the work and safety of the others. So it's, I think that the first thing is to segregate that employee, to ask follow-up questions, to see if you can better assess the standards of what you might get for specific articulable symptoms. I mean, there's no guidance on there, but I think, you could probably do a little research and find out about some of the common physical signs, red eyes, increased appetite, delayed reaction times, and then some of the other, signs of use like panic and anxiety. And again, that's where I think training is going to come in, either in the short term, based on the information that's out there, and then also if we do get regulations. But again, I think it's to isolate that employee, try to gather information, to observe the employee, see if there are any specific articulable symptoms, interview coworkers to see if there are any if there are other observations from employees that kind of corroborate that, and then just be able to make sure you have enough information in order to make an employment decision. The one thing that you're going to want to do, of course, though, is making sure that you're applying that policy evenly, so that Black employees or another employee in a protected classification can say, hey, I was treated differently. When so-and-so showed up high, nothing happened. So there are a lot of things that need to go into it, but I think the first thing that you have to do is really just gather information and conduct an investigation, just like you would for any other type, before taking any other type of workplace action.
Makes sense, absolutely. So these next two questions go hand in hand a bit. So related to restricting the use of cannabis, even where tobacco use may be allowed. Do they have to go hand in hand, or can you restrict one and allow the other?
My understanding, and I'll defer to Stephanie to this, is that you have to treat them the same. So if it's a situation where smoking tobacco is allowed, that smoking marijuana would also be allowed, but I will defer to my colleague on this.
Yeah, I think I don't definitively know the answer to that at the moment, but it's certainly something that I'll go away and have a look into. I think you could probably make an argument on both sides, but I would probably go with what Joe said on that one. You know, I think that in New York, you have a right now to consume marijuana anywhere that tobacco products are allowed per the new law. And so I think that you would probably run into a little bit of trouble if you restricted your smoking section to tobacco products only, without allowing marijuana products to be consumed there as well, because per the law, you can smoke it wherever tobacco products are allowed. So I would say that if you're going to have a smoking area that allows for tobacco products to be, to be smoked or consumed, that you're probably going to have to allow marijuana products to be smoked and consumed in that area as well. And if that, poses a problem, you might want to consider getting rid of your smoking area completely.
Thank you. This kind of segues into this next question as well. Leniency versus alcohol poses a bit of a difficult situation for recreational businesses that may include children and families. Can a business impose a policy that prohibits use, even though, so the business may allow personal consumption of alcohol, even though they don't sell alcohol? Would that kind of be along the same lines?
I think that would probably be along the same lines. So if you're going to, have people consuming alcohol on site, no problem with that. Those people might want to smoke tobacco. And if you are going to, allow that or provide some sort of smoking shelter or area or facility to allow for that, you can probably expect people to smoke marijuana products or, vape marijuana concentrate in that area as well.
Thank you.
However, I would say that just like alcohol, if this is on site where there are children, there is a requirement under the law to keep your marijuana products secure and safe away from children. So certainly if someone is, handing out marijuana products to children at your site, or otherwise, being a little loose and carefree with the products such that children might be able to, take them or consume them somehow, then certainly I would say you have a right to step in at that point and ask them to leave or tell them to take better care of their products.
Thank you. And just a couple more questions here. So both employment related. What about just flat out asking an employee if they are under the influence? Is that going to be something that is allowed or, able to be done?
Yeah, and that should be the first question. If I'm sorry, I didn't clarify that, but one of the things that might happen is the employee will lie about it, and then if you have other information that shows that the employee was in fact lying about it, that could, kind of either result in increased discipline or further cement your basis for taking some type of adverse employment action. So definitely yes. In addition to the actual observation, that basic question, seeing how they respond to it, will get you a great deal of information one way or the other.
Absolutely. So, and just finally, and I know that, we'll be looking and watching for additional regulations that will come out and additional guidance from New York State and the Office of Cannabis Management. But do you know of any current testing regulations specific for, say, forklift or truck drivers as of yet, any, vehicle use as it relates to the new law?
I'm generally aware of the U.S. Department of Transportation having regulations that deal with drug and alcohol testing programs. And my understanding, those are still in effect, and there's really been no guidance as to how that will interplay with New York State's recreational marijuana law. So that's an issue that we're, monitoring for further developments. But it raises that question when I talked about New York labor law, section 201D, some of the exceptions that come into play when an employer has obligations under either federal law or federal contract. That's definitely an area where you're going to need more detailed legal analysis because, as we stated repeatedly, it's still a controlled substance under federal law. So, again, we're going to be looking to your lawyer for further guidance on that, because it's unsettled at this point as to how those those two interplay.
Great. That was all of the submitted questions. So if there's any other closing remarks on your end or anything else you wish to share.
Just to wrap things up, but again, thanks for having us. If there are questions we weren't able to answer or participants weren't able to get to, feel free to reach out to us at any time. And again, we're expecting further regulations, so make sure you stay up to date. And one of the ways you can do that is following our newsletters, on LinkedIn, Twitter, Facebook. And, we freely share that information and hope it's of value. So thanks again, Christina, and thanks, Stephanie and Ryan for joining us today.
Yes, thank you to all of you. As I say frequently, we value the partnership that we have and the opportunity to engage in conversation with our members this morning and to continue to push out this very important content. We will make sure that, as new information continues to become available, that we will share that. Again, this recorded presentation will be able to be found in the video resource archive in Member Information Center. If you are joining us this morning and are not yet a member of our Cheektowaga Chamber of Commerce, we'd love to have a conversation with you, and I'll be following up after the call. So again, thank you all, and we look forward to hopefully seeing everyone in person very soon. Have a great day, everyone.
Bye.